Generally speaking, in order to obtain permanent residency through marriage to a United States citizen, an individual must have entered the United States lawfully. That is, they have to have been inspected and admitted with a visa. If they have not, for example, if they entered the United States without inspection, they are not eligible to apply for permanent residency. Their spouse can file a petition on their behalf, but the person would have to depart the United States and attend an immigrant visa interview in their country of citizenship in order to obtain their permanent residency. The problem for many people is that if they've been unlawfully present in the United States for a period of more than 1 year, at the point of departing the United States, they are barred from returning for a period of 10 years. This departure bar only happens at the point that they leave the United States. So there are many individuals for many years who, although they have been in relationships with United States citizen spouses, have been unwilling to depart the United States because they would incur this type of punishment. Now, there is a waiver or a type of forgiveness available for people who are married to United States citizens who have to depart the United States, but until recently, the individual could not apply for forgiveness of that punishment until after they had left the United States. And in many cases, this was a very long process of applying for the waiver, during which the person would be stuck outside the United States and wouldn't even know if they were approved for the process until after a decision had been made. And if that decision was a denial, then they'd be stuck outside the United States for a period of 10 years. The administration has changed the processing of these types of waiver applications to allow for the forgiveness to be applied for before the individual leaves the United States. And this means that the law is still the same. The person would still incur this 10-year punishment for departing the United States after 1 year out of status, but they could apply for forgiveness before they leave so that they could attend their immigrant visa interview overseas knowing that they've been forgiven from that punishment and will be able to return to the United States without that type of bar. There are 3 parts to this type of process. The first part is that the U.S. citizen spouse has to file a petition for alien relative on their family member's behalf. That petition has to be approved. After the petition is approved, the matter is transferred from the Department of Homeland Security to the State Department. The State Department issues an invoice for the government fees for the immigrant visa. Once the individual has the approval notice for the petition for alien relative and the receipt notice for the payment of the immigrant visa fees, they can submit the application for the provisional waiver to the Department of Homeland Security. In order to have the waiver approved, the individual has to demonstrate that if they were to be denied the waiver, that it would result in extreme hardship to their U.S. citizen spouse. If they can demonstrate this and the government wishes to give them the waiver as a matter of discretion, and if the individual can show that there are no other problems preventing them from becoming a permanent resident, such as no criminal issues, no issues involving immigration fraud, no issues involving deportation proceedings, then the waiver can be granted, the individual can depart the United States to attend their immigrant visa interview, and then re-enter the United States with their immigrant visa and become a permanent resident. Okay. Provisional waivers in Spanish.